Yes, Mr. Earl.
May it please you, my lady. As you'll have seen, I appear with my learned friend Mr. Schoenfeld for the appellants, and my learned friend Mr. Wheeler appears for the respondents. We both have behind us Miss Christian and Miss Pegg, who very capably presented this case before in the Isle of Man. My lord, I'm feeling slightly old school here because I'm the only person who's surrounded by large files with sheets of paper in them.
Not quite. I think you'll find one or two of us still use paper core bundles, but we would certainly appreciate electronic page numbers.
Yes, of course. Yes.
Whenever you can, because that's the way we tend to operate now.
Yes. Well, the court this is the electronic bundle that the court has printed out, so I'll be referring to the page numbers in that. So you know that this is an appeal from the Isle of Man Court of Appeal, which overturned the decision of the Deemster in our favour. The key issue before the Privy Council is whether this case should go to trial or whether it should be struck out.
Well, we're most grateful to both parties' written cases, which have been extremely helpful, if I may say so. So please feel you can plunge straight into the middle of it, and by all means concentrate in your oral submissions on particular parts. We will not assume that because you haven't concentrated in other parts, they don't remain your case.
No, that's very helpful, my lord. The Privy Council are aware there are 10 grounds of appeal, and there are really, as a matter of law, 3 of them that I was going to focus on, which I will in a moment. Inevitably, in a case of this sort, the facts are very important. And before going to the law, I was going to take you to, briefly and effectively, I hope, to some passages from the evidence, and then to the pleading, which is the subject matter of the strikeout application. Both of those are in what I have got as bundle 2.1, but I'll take you to the relevant page numbers when we get there. The fundamental starting point is that the facts asserted by the appellant are assumed to be correct for the purposes of the hearing. You'll have seen procedurally that the bank has not filed any substantive evidence or filed a defence or given any disclosure. And so this is a very pure strikeout application, if I can put it like that, which is based entirely on the pleading and the assertion that, as it were, however the facts may turn out at trial, this case is hopeless and should be struck out. And we say, as you know, that the Deemster got this right, that there is a sufficiently arguable case. It's an interesting case in law. It's highly fact-sensitive. It ought to go to trial. And that the Court of Appeal were fundamentally wrong in allowing the appeal and striking out the case. In one sense, the starting point, my lord, is the test that you should be applying in a strikeout application, which we've dealt with in 2 places in our written submissions. There's reference in the written submissions, as there are in the judgments below, to the position in the Isle of Man, which effectively has adopted the test of Lewis and J in easy air. And there are 2 or 3 different aspects of it. One is that the case should be hopeless, not fit for trial, and incontestably bad, as it's put in one of the authorities. There is a further question that a case which is involves interesting new and developing principles of law should proceed to trial so that those questions can be determined on actual facts rather than assumed facts. And although it's not in the cases before the Privy Council, there's a helpful statement from our Lord Briggs in a case called Vedanta Resources in 2019, where your lordship said that difficult issues of law are best resolved once all the facts have been ascertained at a trial rather than upon the necessary abbreviated and hypothetical basis of pleadings or assumed facts.
That was no doubt thought to be too obvious to need to be put in the bundle. Mr. Earl, I did look for it, but it wasn't there.
But it is, if your lordship will give me, one of the clearest and most helpful statements of principle, and it's one that we say is directly applicable in this case. There is a more recent case which is now commonly relied on in the lower courts in England, called Begum and Maran, and a judgment of Lord Justice Coulson, which has now, as it were, taken over from the easy air test. And essentially, his lordship in that judgment, again, that's not in the bundle before the Privy Council, but summarises and draws together the principles that they've been developed. One point is that the procedural issue as between the two rules for striking out and summary judgment, that the rules should be taken together and a common test applied rather than there being any distinction between them. And of course, as I say, my lord, in this case, there is no distinction because this is not a case where the defendant had put the facts in or put in any substantive evidence. The correct test... It's not suggested, is it, Mr. Earl, that there's any difference in the test because it's the Isle of Man rather than England? No, I think.
So what's the Coulson case?
Sorry, my lord.
What's the Coulson case you're referring to?
It's Begum, B-E-G-U-M, v. Maran. It's not in the...
Not in the bundle either.
No. Okay.
Does that reiterate the easy care principles that you referred to at the outset?
Yes, it does, yes. And Lord Justice Coulson says there that the real test is that it should be certain that the claim is bound to fail, that the striking out is for clear and obvious cases where the legal basis of the claim is unarguable and almost incontestably bad, and that deciding questions of legal principle without knowing the full facts is unsatisfactory, and decisions as to novel points of law should be based on actual findings of fact. So we respectfully say that that is the approach that should be adopted in this case. That is not the approach that was adopted by the Isle of Man Court of Appeal, who adopted a very different approach, and we refer in the written argument, I won't take your lordship to their judgment, but in paragraph 2 of the Court of Appeal's judgment, they treat it as a matter of us proving our case. So the onus, they say, is on the appellants and not on the respondent or on the claimant and not the defendant. And they say that the test is a balance of probabilities. Well, my lord, with respect, we say that is simply wrong. As Lord Hobhouse very pithily put it in the Three Rivers case, the test on strikeout is absence of reality, not balance of probabilities. And the onus, as I think my learned friend accepts, is on him and not upon us to establish that this is such a case. So in terms of the Court of Appeal's starting point, we would submit that they approached this in the wrong way, and as a result, or partly as a result of that, reached the wrong result. Now, it's important for those reasons, and more generally, to just take your lordship and ladyship, if I may, to the facts and the pleading. And I'll do that quickly by reference to Mr. Royal's witness statement, which begins at bundle page 165.
1065.
165.
165, thank you.
It's in what I've got as bundle 2.1, but I don't know how the electronics work.
Well, that worked electronically. Well, there was a time when one was always 1 or 2 or 3 pages out, but luckily those gremlins seem to have been firmly laid to rest.
So, in this statement, Mr. Royal explains from the point of view of the receivers who are have the conduct of these proceedings on behalf of the claimants, the important factual aspects. And I can take the Privy Council quickly, I think, to the passages which I need to rely on. You'll see on 166 the purpose of the witness statement is dealt with, and then over at 167 in paragraph 3.4, Mr. Royal sets out some of the key respects in which important matters in this case remain outside the knowledge of the claimants and the receivers. And you'll see, just going through them briefly, and he refers there to the know your client processes within the bank, due diligence in relation to SIOM, the customer, which is effectively a shell company which was simply administering the accounts, the information and documentation surrounding the operation of the accounts themselves, the extent to which RBSI had knowledge, as it clearly should have done, we say, that it had been compliant with its regulatory obligations of the underlying investment scheme, the legitimacy of the investments and the roles of the various individuals, including those who turned out to be fraudsters. An explanation as to how, as we know it was, this venture and these accounts came to be defined by the bank as high risk, and I'll take you shortly to the documents that deal with that. The events which you'll have seen are referred to in the pleading and in our written case, which he deals with in subpara bracket 6 on page 168, where the initial and reputable directors of the company administering the customer SIOM resigned almost immediately because of their concerns that the documents were untrue. And there is also obviously the important question of how the change in the description of these accounts came to be made from SIOM, the shell company and customer, to make express reference to the underlying beneficiaries who are the appellants. And he's right in my submission to draw attention to those points, because they are all matters that can only be dealt with by the processes of disclosure and witness evidence and can only properly be considered at trial. Now, just going quickly through the following pages, in paragraph 4.2, he explains what the segregated portfolio companies are. As the Privy Council will have seen, they are Cayman companies, not in the Isle of Man. And they were managed and administered in Cayman by people who were not at all involved in the fraud. And so there was a clear division between the visibility of those administrative funds themselves and the individuals and entities who were effectively operating the investment scheme through the bank accounts in the Isle of Man. On page 170, you'll see that he refers to, in 4.7, to a gentleman called Dominic Lawton Smith, who was and JP Fund Administration, who were in Kent administering the scheme, administering the funds rather. And at the end of that paragraph, he points out that it was Mr. Lawton Smith, as I'll show you in a moment, who was responsible for instigating the change name because of his concerns that the account should show on their face who were the beneficial owners of the funds which they contained. And then from 170 over to 172, Mr. Royal explains the important role of the investment manager. There were two of them, Synergy Solutions and then Tangerine Management, both of which were controlled by the crooks, as we now know. And then he deals with SIOM, which is the client's, the customer of the bank, which was the loan originator or loan manager. And that, as you will have seen, had firstly Clearwater Fiduciary Services until they resigned because of their concerns as the company actually managing. And then a company called Treadstone, which took over for most of the relevant period. He explains in 5.3 on 171 the important role that SIOM had as an administrator. But it is an important part of the factual context in this case that that's all it was. We have no idea exactly what the relationship was between RBSI and SIOM, because we haven't seen the mandate, we haven't seen any of the contractual documents or the terms and conditions.
But wasn't this explained in the materials provided to the investors? You say the bank knew and should have known all of this, but shouldn't the investors, they know all this as well?
Well, my lady, the investors only had sight of what was provided to them in the formal documentation that essentially set out the terms of the scheme, the memoranda as they're referred to, and those describe the scheme as it should operate, as it was intended to operate. And we'll see when we come to the pleading that they placed very close constraints on what the role of the fund manager and what role was to be held by the loan manager. And in any event, he then sets out over pages 171, 172 the initial concerns that came to light when the two directors of Clearwater, the company which was providing fiduciary services to Scion in the first instance, they both resigned, and because they felt the documentation that was being provided was misleading and inaccurate. So right from the start, the appellants say there were clear red flags in the Isle of Man known to RBSI, which were certainly not known to the investors in all the administrators and directors in Cayman, administrators of the funds. My lady, you'll see in paragraph 5.5 on 172 and 173 that he then refers to the SOM as it's been defined, the supplemental offering memoranda, which are the series of documents which set out how this was intended to operate. And he quotes from one of those on page 173, which provides a fairly detailed analysis of the limited role of the loan manager, Scion. And as he points out at the end of 553, RBSI should have been aware that the investment manager was never to handle fund monies. And fundamentally, the administration of the monies in the RBSI accounts was to be dealt with by Scion. And Mr. Schools and his various companies and and the other individuals should not have received any of it. What we say, and I don't think this is really an issue, that this scheme was extremely straightforward. It involved two bank accounts at RBSI and the Isle of Man. One, the purpose of the first, the main account, was to receive investors' funds from the Deutsche Bank account in Cayman, and then distribute those funds to UK law firms to fund, to provide litigation funding. That was its only purpose. That was Scion's only purpose with that account. And the second account was to receive monies, loan repayments from UK law firms. So the system on its face, we say, the operation of the scheme was very straightforward. And what happened, in fact, was very obviously not what was intended to happen to those who could see what was happening. In other words, RBSI and the others involved in the Isle of Man, and certainly not the investors or the directors in Cayman. And he then, in paragraph 6 on page 173 and 174, explains the movement of monies from Cayman, at least as it was intended to operate, through the main account and to the law firms by way of loans. And then I won't trouble you with 174, 175, which is the more of the history. But he then deals with the banking relationship in paragraph 7 of paragraphs 176 to 178. And there are a couple of important factual points that I wanted to draw to the court's attention. In 7.2, you'll see he refers to Mr. Arthur was at Turnstone, the services company that was effectively acting as a managing director and administrator of SIOM. And he makes the point, which we say is important in 7.2 and 7.3, that it's clear from the documents we do have that these accounts were being operated by individuals at the bank. There was a relationship manager. There are a number of indications in the documents that they were dealing personally with these matters. It wasn't one of those cases where there were the transactions were all simply electronic without any human intervention, which is important. Nor was it a case where, as one sometimes sees, there were thousands of different transactions in which a fraud was buried. There were a relatively small number of payments, and indeed when one comes to look at the payments which were made, a very large number of them were actually fraudulent and going to parties that they shouldn't have gone to. So again, as a starting point, a strong starting point, we say this was an obvious fraud within a simple structure, and even the most basic due diligence or investigation of who was doing what and what was actually happening would have disclosed what was going on. He deals with the accounts on page 177, the accounts we're concerned with. And then, if I could take you to 179, he deals in relation to those accounts with the issues concerning the name change. And you'll see he says the issue of the SIOM, this is 931, the issue of the SIOM Bank was raised again later in 2011 when by chance DLS saw a copy page from the statements with the name Synergy IOM rather than the name of the fund. He wrote to the contact at Turnstone who bore responsibility for the account, Mr. Arthur, on 24 November 2011, asking the names of the accounts be changed into the names of the fund to demonstrate that these assets are held for the fund, because the bank account should reflect evident title to all of its assets at all times. Arthur's response on the 25th of November mentioned some other problems, Synergy-related people and other accounts in the name of Synergy. And then we see in 933, Mr. Arthur made a suggestion that that SIOM should be converted in some way into a protected cell company to accommodate the concerns. The response from Cayman was that the monies held in the client accounts are clearly marked as such, particularly the client is identified or effectively held on trust, and so although legal title vests with the organisation running the accounts, there's an overriding beneficial interest and claim that can be asserted by the client as beneficial owner. So that's as between the funds and Turnstone in the Isle of Man, and that name change to the accounts is then effected as he records in the following at the bottom of 179 and over to 180.
It's clear, isn't it, from 9.3.4 in particular, that this didn't come about as a result of any direct contact between the funds and the bank?
No, it was contact through
intermediate.
Through the intermediary, yeah. Yes, but it clearly originated from Cayman. And then what's clear in any event, and only this, is that those name changes did take place towards the end of 2011. The only purpose of making those changes, we would respectfully submit, is the one which was indicated by the funds themselves, namely to make clear that these were not accounts of SIOM, but although they may be held by SIOM at the bank, they were accounts where the underlying beneficiaries were the funds, and that, we say, is precisely what the changes did make clear.
Can I just ask in relation to paragraph 9.3.3, this is really just a point of information that you may be able to help me on. When there's reference to client accounts, is one then always dealing effectively with trust? I mean, is the term client account in the banking world equivalent to a situation where those funds are always held on trust for beneficiaries?
Yeah, my lord, we would submit yes, it is. I mean, it's not. One would need expert evidence to decide whether it is a defined term of art. But
do we gather from this? Sorry, have you finished?
Yes.
Do we gather from this account that there's no regulatory obligation on the bank to ensure that when it's aware that the account holder is actually holding the funds on trust, the bank is not obliged by regulations to make sure that the name of the account reflects that?
I don't.
Is that what we conclude from this episode?
One of, as your ladyship will have seen, one of the real concerns we have about the absence of disclosure in this case, because it's a strikeout application, is we haven't seen any of the compliance or regulatory material. Clearly, the anti-money laundering regulations in the Isle of Man will indeed.
That must be in the public domain, what the regulations are on a bank, as far as naming of the account.
Yes, I mean, and your ladyship will see we've set out in the pleading the basic regulatory obligation. One's always very concerned in these cases not to get into the awful position that some people, past litigants, have before the courts of seeking to argue that because they're under a regulatory obligation, ergo they're under an obligation, a civil obligation in tort, which is obviously not right. But the short answer is I don't know what specifically the Isle of Man regulations provide in relation to the naming of accounts. I don't think we've found anything that specifically deals with that. And that certainly isn't the reason why the name change took place. So that, as you'll have seen from the chronological, as it were, analysis of the case and the red flags which took place, that was a very important point in this case. I just finally draw your attention to pages 181, 182, where Mr. Royal refers in 10.1 to the reference to the account being high risk at the bank, which I'll take you to in a moment, and then continues to identify over that and the following pages the further what we've termed and what he terms red flags, which there were in relation to the operation of this scheme. So in terms of the facts, and before going to the pleading, Lord, I just wanted to take you to the key documents, and there are one or two emails to look at, which deal with the matters we've just seen in Mr. Raw's witness statement.
Mr. Earl, just so I can be clear, we're not today concerned, as I understand it, with whether, if there was a quince care type of duty owed to the beneficiaries, your clients, as plainly there was to Scion, it was triggered.
No.
I think we're proceeding on the assumption that it was triggered. And we're not, I think, concerned, are we, with the question whether the bank knew that the funds were the beneficial owners of the accounts? We're only concerned, aren't we, with the cold legal question whether there was a duty of care owed direct to the funds?
Yes. But clearly, when you come to consider assumption of responsibility and the other various elements, how this matter developed, the red flags, the warning signs, the degree and extent to which the bank was put on notice over time, increasingly, we say, by what happened, is an important part of the analysis as to whether, because this is not a case where one simply looks at the outset and says, was there a tortious duty as well as a contractual duty, and if so, what was it? Because that duty could well have arisen during the course of the dealings between the parties. And crucially, it could if it hadn't arisen before.
During the course of what dealings between the parties?
Well, excuse me, I'm not sorry. More through, Lord, I shouldn't have put it in that way. You're quite right. More through the operation of the scheme in the Isle of Man by the bank, because I mean, your lordship's right that the funds didn't have any direct dealings with RBSI. So, my lord, I was just going to take you very quickly to the emails dealing with the name issue, if I can put it like that, and they are at page 247. They're in reverse order in the court's bundle, so that chronologically they start at 247. And you'll see on that page, and going over to the next page, is an email from Mr. Lawton Smith at the funds to Mr. Arthur, copied to schools and others. And on 248, he asked, would it be possible to amend the account name on your and the relevant bank records to demonstrate that those assets are held for the fund. And he refers to the copy of the statement he's seen, which is named Synergy, IOM, rather than referring to the funds. And he then says, as is obvious, I'm keen the fund retains evident title to all its assets at all times, whether these are debts owed by law firms or monies held in the fund, however briefly. Then the response to that email starts at page 245 from Mr. Arthur.
Just remind me who Mr. Arthur is. Is he at the bank?
Arthur's at Turnstone, who are managing the. This is correspondence at the moment between, although obviously this change is an important one which will have to be effected by the bank. We don't at the moment know what happened as between the bank and Turnstone. We simply have the communications between the funds and Turnstone in the form of Mr. Arthur. And he responds to the request in terms which was accurately described by Mr. Royal in his witness statement. You'll see the fourth paragraph on page 245. He says, I'm very conscious now that we are at a conjecture where, with the certainty of increased due diligence, probity due to bigger players coming on board as investors, concerns will be raised at the lack of segregation, irrespective of the reality as stated above. And then Mr. Lawson Smith responds at 244 on the same day. We see in paragraph 1, as I'm sure you're aware, that this is clear that there is clear evidence the monies held in the client accounts are clearly marked as such, particularly where the client is identified, are effectively held on trust. And so although legal title vests with the organisation running the accounts, there is an overriding beneficial interest and claim that can be asserted by the client as beneficial owner, etc. And anyway, we can see what he says over those in that email. And then finally, at 243, Mr. Arthur responds, as you'll see, RBSI's legal team have come back to me and they are happy for the two bank accounts to be designated as client accounts and accordingly would be treated as segregated by the bank, and they would be renamed as follows. This should hence address the concerns that have been raised. So certainly as far as what the funds were told, to deal with your ladyship's point earlier, there has clearly been a communication between Mr. Arthur and the bank either with their legal department or the bank have consulted their own legal department, as a result of which they have made this important change for the reasons which Mr. Lawton-Smith requested. And what we say self-evidently, that at the very latest must involve an assumption of responsibility on the part of RBSI that the funds held in the account, while they may legally be those of SIOM, are beneficially those of the fund, and that as part of as one of the processes to make that clear on its face, the account names were changed.
Is it the change of the name, or is it the fact of the name? So if from the outset they had been called by these names that were then introduced, what would be your position then?
It's both, my lady, we say, in this sense, that given that the terms of the scheme itself, we say it must have been obvious to the bank, had they read the various memoranda, how this scheme was meant to operate, and it must have been obvious to them that the monies were being transferred from Cayman beneficially to be held by their customer, which was effectively an empty administrative vehicle with no real substantive involvement, just only administrative. And so part of the appellant's case is that throughout, following in particular the resignation of directors through their concerns in 2009, but throughout the RBSI should have been aware. But certainly at this point, this is the best we've got because we haven't seen any of the communications.
So the awareness of the fact that there are beneficial owners of the monies in the account, that gives rise to the assumption of responsibility towards those beneficiaries?
Yes, that is part of our analysis. It's not simply that the name itself may not be significant. I accept that, but certainly the fact that it has been changed to make clear the beneficial ownership is, we say, significant.
Well, that's what I'm trying to press you on. What is the significance of significant in what way? I can see. What I'm trying to understand is how does the change of name affect the assumption of responsibility? Is this a fallback argument on your part that if there would be no assumption of responsibility just from the material provided to the bank when the accounts were opened, you rely on that as an assumption of responsibility, but is this a fallback argument? Well, if that didn't give rise to an assumption of responsibility, then it at least arose here. Is that how you?
Well, it's my lady. You use the phrase fallback. It is a fallback in the sense that we say at the latest by this date.
Right.
It was quite clear to RBSI that it was
leaving aside the question of when, and I think when you're replying to my lady by saying it's a fallback, it must be at the latest by the change of name. But why does knowledge by the bank that its customer is using the account as the repository for the monies of a particular third party on a trustee beneficiary basis involve an assumption of responsibility by the bank to take care to avoid that beneficiary being harmed?
Well, it's in the name of the account, my lord, involves a recognition by the bank that it is dealing with and knows that it's dealing with the funds, the appellants' money, beneficially owned by the appellants.
So you say whenever a bank knows that the funds which are, using the sort of quaint concept of money sitting in some kind of box, that the funds in an account are beneficially owned under a trust by some third party, the bank assumes responsibility to that third party to take care to protect it from loss.
Well, my lord, we do say that in this case, on the facts of this case, but absolutely we don't say whenever that happens, because in any particular case the court needs to consider the specific facts it's concerned with. And here this name change took place as part of a continuum of activity on these accounts, which, as you will have seen from the pleading, we say started much earlier than this and caused continuing and increasing concern in relation to a very simple investment scheme as to what on earth was going on. And by the time, to the extent anyone dealing with this at the bank might have claimed not to know who the underlying beneficial owners of these funds were, namely segregated funds in Cayman, certainly by the time these changes were implemented, so we're told after consultation with the bank's legal department, it was clear to the bank then who the beneficial owners were.
Sorry, are you saying then that it's, in order for there to be an assumption of responsibility, the bank must know not only that there are beneficial owners, but who the beneficial owners are?
Well, we pleaded, it's been pleaded in the alternative, namely that if the bank knows there are beneficial owners or knew on the facts of this case that there were beneficial owners, even though it didn't know their identity, is the first, as it were, chronological point. That is sufficient. But then, once it does know the identity of the beneficial owner, namely the appellants, which it clearly did in late 2011, it owes a similar, but I suppose slightly different duty in this sense, that if it was under a duty prior to that date, that duty would also have included finding out who the beneficial owners were, which it could very easily and quickly have done by asking Turnstone.
Well, maybe the beneficial owners don't want Turnstone to tell the bank their names.
Well, as your ladyship has seen, what in fact happened here shows the exact opposite, because they did, and they had they were very keen that that should happen for the reasons that we saw in the emails. So in terms of
the email seems to have been concerned with proof of title to the money if some issue of ownership should arise.
No.
As I read the earlier emails that you showed us, rather than misappropriation. Well, in other words, if, and one doesn't know the answer, the reason for the fund's concern as expressed in its email was transmitted on to the bank's legal team, the reason doesn't appear to have been a concern about misappropriation, but a concern about being able to prove title to the money in that account.
Yes.
Ownership, in other words.
Although, I mean, she'll also consider from our point of view, because of where we are and the fact we haven't seen any of what actually happened or any of the dealings between the bank or internal rules of why this important change was made, I accept we can't answer that question. And it's what, no doubt it will be if you allow the case to go forward. It will be an extremely important factual issue for the purposes of the trial.
Your key proposition is that there's an assumption of responsibility either when the bank knows that there are third parties behind the funds, i.e. beneficiaries of those funds, and or when they know the name of those third parties. Who
the actual beneficiary is.
Yes. But I suppose the problem I've got is at a prior stage as to whether either of those get anywhere near what the law means by an assumption of responsibility. I mean, that sounds to me extremely wide as an assumption of responsibility, because the third parties are not placing any reliance in any direct sense on anything the bank has done or said to them. You're outside a contractual relationship between the bank and the customer. So where are you getting this assumption of responsibility just because you know that third parties are affected or the name of those third parties. Why is that an assumption of responsibility?
Taking it in, as it were, chronologically, Lord, one has to start at the earlier stage when the bank may not have known the beneficiary or who the actual beneficiary was. But they did know, or at least should have known, we say, what this scheme was. Because as part of their know your client and due diligence obligations, they must have had on their in their records all the memoranda and other scheme documentation. And it would be, we say, a fundamental regulatory obligation, quite apart from anything else, for them to have been properly informed as to the scheme that they opened these bank accounts to operate. And they were supposed to be the only bank accounts being used to that scheme. And when one starts at as it were, the beginning of the story, the bank knows that's the position, and then increasingly over time, it's clear, or it should have been clear to RBSI, that the scheme was not being operated in accordance with the scheme documentation at all, and in ways which were, we say, very obvious indeed. In other words, monies were being paid out of the main account, firstly to something called a house account, which Scion had formed, which wasn't part of the scheme at all, and was effectively used as a conduit through which monies then went to the fraudsters.
I can see all that goes to whether or not there were red flags fluttering in the breeze. But why does that go to the question whether the bank assumed any responsibility to take care to protect the beneficial owner of the account from the consequences of what those red flags suggested might be going on?
Well, my lord, we say, as it were, incrementally over the period that the more the bank becomes aware, or should have become aware, that the scheme it was meant to be operating for beneficially, ultimately for the funds, or let's say for someone they didn't know the identity of the funds, but the more the bank comes to know that the scheme is not being operated at all as it should have been, and in fact monies, rather than being paid to solicitors firms in England, are being paid to the Marshall Islands, and you've also seen the and all the rest of it, effectively to the fraudsters. The bank sees that the investment manager, who's effectively schools, where it's not supposed to be, is not supposed to have anything to do with the money, only Scion and the solicitors, and yet these payments are being made to schools, to the investment manager, to his various individual and corporate fellow conspirators. We say, is just as a matter of basic application of the authorities, that all leads to the bank, when it continues making payments without carrying out any checks at all, to the bank assuming responsibility in relation to those whose the monies are being misappropriated.
But
and when,
as I understand, your case does have these various levels, but at the third level, so to speak, it's your submission that a duty at least arguably arises in circumstances where the bank had grounds for suspecting a fraud against the beneficial owner.
yes.
And that may or may not be something with which your opponent agrees, but that, I understand, it is your case.
Yes, it is. And then just finally on documents, before I move on, and all, shortly after the exchange we just looked at, there's an email at page 249 from Mr. Arthur to someone called David Ray, who was one of Mr. School's fellow conspirators, where he's describing the present administrative position in relation to the scheme. This is now January 2012. You'll see on that page and the next page he refers to various processes. And then at the bottom of 250 goes on to deal with, under a heading, due diligence. And over the page, we see we have obligations to both the bank and our regulator in relation to compliance documentation on the various parties connected to Synergy IOM. The bank have always deemed SIOM as a high-risk case, owing to the large sums and number of parties involved. And the sums involved have recently increased substantially. I mean, as it happens, my lords and my lady, that is a reference to fraud. I mean, what's increased substantially are the large numbers of fraudulent payments that are being made through these accounts. So that there's no question at all on the, again, we don't have the internal documents, but there's no question at all if this is right, that the bank defined this as a high-risk case and therefore obviously had, we say, concerns about what was going on. And 2 paragraphs further on, you'll see he says, what I'm keen to preempt ultimately is the bank withholding any payments owing to a lack of documentation on our part, as evidently this would interrupt the smooth running of the fund.
I'm sorry, which page? Oh, I've got it. Yes, thank you. Yeah, I've got it.
It's 251
yes.
and 3rd paragraph.
Thank you.
So, in fact, the very elements which form the subject matter of the so-called quince care duty, or its principal subject matter, in other words, the bank not making payments until it's made a reasonable inquiry, is the very matter that he's referring to in this email by reference to the bank's position. His concern is that the bank is indeed, because of its concerns, because it's a high-risk case, going to withhold payments. And it's again, it's difficult when we have such few documents, but the substance of what's happening here does seem to draw a distinction between SIOM, the customer, and the beneficial owner, because what he's saying is the bank, in relation to SIOM, wants SIOM to produce various documents because the bank is sufficiently concerned about what's going on that if it doesn't get them, it will withhold payments, in effect, to protect the underlying beneficial owner of the funds.
And that's the 31st of January 2012?
That's January 2012. And then, sorry, I said finally, there is one further exchange to draw your attention to it. Page 257, just a little further on in the bundle. You'll see an email again, this is the end 31 January 2012, from someone who I think is a Swiss fiduciary or lawyer at a Swiss company called Portland Financial Management, who were responsible for managing some of Mr. School's assets and offshore companies in Switzerland. And he's in correspondence with Mr. Arthur of Turnstone. You'll see he says, as per our phone call, please find attached updated information regarding the directors of Portland. So at that stage he's giving directors. Over the page at 256, again they're in reverse order. Dear Ben, bottom of the page, as per our conversation, please find attached the requested certified documents by Swiss authorities, as well as the board minutes of Noble. Noble, as you may have seen from the documents, is one of the recipients. It's owned by schools and is one of the recipients of the misappropriated monies. So he's providing that information. Then further up the page, there's an email from Arthur to him. Second paragraph, I think there's just one more thing we need for the meantime, which is a letter from Oxbury, etc. And then finally, at page 255, at least finally, this is all we have, from Arthur again on now the 1st of February 2012. Thanks for the documents, he says. A large part of this exercise is being undertaken further to a request from SIOM's bankers, and the other documents they are requesting at this stage are, and then there's a certificate of incorporation, memorandum of articles, etc. So there is again clear evidence that the bank internally, its compliance, its lawyers, whichever it is, perhaps all of them, are engaged in seeking information in relation to payments which are in fact fraudulent payments which bear no relation to the scheme as it should have operated, because none of the money should have been going to Noble in Switzerland, as we now know. And so although we only have, I accept Mr. Arthur's presentation of this, and of course he can give evidence at trial, but we don't know the bank's internal position. What he is again saying here is that these requests for information are being required by the bank, which again we would submit is a very clear indication that the bank has assumed responsibility in relation to what is happening on these accounts shortly after the name has been changed, and the only real basis.
Mr. Earl, the bank clearly had, as we now know, a quince care duty to Scion.
Yes.
And had a responsibility, whether it, and probably knew it had a responsibility to take reasonable care, not by honouring some instruction from an agent of or officer of Scion to cause Scion loss. But why do you, or where do you get from these passages, I'm thinking particularly of the one on page 251, an indication of an assumption of responsibility not towards Scion, but towards the owners of money in those accounts?
Well, my lord, because the whole reason why this would have been defined internally as high risk to start with is because there was a risk that the arrangement of which Scion was administering might be abused by the investment manager, or the people behind the investment manager, Mr. Schools and others.
Yes, so as to cause prima facie a loss to Scion.
Well, my lord, except that the reality is that Scion has no substantive commercial involvement in this at all. It's simply an administrative company. It was, in our submission, it's unreal to say that in this type of arrangement, and this specific arrangement, where the company is literally a cipher, the customer, where all the substantive benefit lies with the beneficiaries, and where, under what should have been a very simple scheme, monies are coming from the Deutsche account in Cayman into the Isle of Man, and then they should simply have gone out as loans to solicitors in the UK. It's a very straightforward scheme. And the reason for the risk that the bank, as the bank has defined it, the reason for the bank seeking information is precisely because, in order to protect the underlying beneficiaries, they need to know what's going on, and that is, in a sense, these documents suggest to us, we would submit to the court, inadequate though they are, that the bank did indeed accept some form of responsibility to the beneficial owners of the funds, and was in the process in some way of performing that function, not because it thought that Scion might be damaged on the face of it, because Scion wouldn't have been damaged at all with respect, because it had no funds, but because ultimately the only party who was ever going to be damaged by this, namely my clients, would be and would have their funds misappropriated.
Do you accept that to establish a duty of care, you have to establish assumption of responsibility?
No, we haven't accepted that. It's one of the three ways in which we deal with it, as your lordship has seen. And that the first is established authority, which I'll come to in a minute. The second is incremental development, and the third is assumption of responsibility. And that all the Court of Appeal rejected all three as hopeless and unarguable. But if the approach which the court is taking is an assumption of responsibility, we say that over this period, and certainly at the very latest by the end of 2011 and early 2012, the bank had clearly assumed responsibility. So, my lord, those are the only documents I wanted to take you to. I was then going to go to the pleading itself, which is at page 44, and I can hope take that quickly. I know that you'll have had a chance to read it. The process, as you've seen, which was adopted in this case, was to append the particulars of claim from the English fraud Chancery Division fraud claim to set out the facts rather than lengthening even more the pleading in this case. So the particulars of claim, amended particulars of claim, looks in the bundle to be rather longer than it is because it has a very substantial document attached to it. But it starts at page 44, and just turning or electronically turning the pages, you'll see that it deals with the parties to start with, including the fraudsters and their various companies and entities, and explains those who were involved in or should have been involved or were involved in the operation of the scheme, including on page 49 the Cayman administrators. It then sets out in section C from page 49 onwards at some length the various offering memoranda as they changed over time. And what we get from that, as you see from our written case, is that the function of the investment manager was very limited and was circumscribed such that the investment manager should not have had any involvement with the receipt of monies, that the role of SIOM as administrator was also circumscribed, and that the only payments, the whole purpose of the scheme and the only payments were to be made to qualified law firms in the UK for the purposes of funding litigation. That was the sole purpose of this scheme, and it had no other purpose. So that on the face of those documents, and we say it is to be inferred that the bank must and certainly should have had them and considered them before agreeing to open accounts which were for the purposes of the scheme itself. In opening the accounts, the bank should be taken, at least at this stage and for the purposes of a strikeout, to have been aware of the permitted uses under the documentation, and to be fully aware of the very limited roles of the various parties involved, and to have understood that, because it really wasn't very difficult. So that when something very different happens and the bank is making payments which it shouldn't be making, we say it, and it's impossible to take one of my Lord Kitchen's point, it's impossible to say precisely what date, but increasingly over time, the bank is put on notice. There are numerous red flags occur, and as we have seen, the bank appears on the documents to have assumed some responsibility on the basis of internal legal advice as to the proper conduct of the scheme to protect the beneficiaries or the owners of the funds. So those are the offering memoranda. The pleading deals with the accounts at page 57, the two main accounts that we're concerned with. And then at 59, it deals with the renaming, and I've shown you the actual evidence in relation to that through to 63. And you'll see the way the case is pleaded is that at the end of paragraph 60, 4 lines from the end, in any event, from at the latest the time that RBS was first approached in relation to this renaming, precise date of which is not known, RBS was on notice that the monies in the client account were beneficially the property of the master fund. And then in 63, the pleaded case is that in particular in view of the requirements of those are the money laundering codes which have been referred to earlier in the pleading. RBSI ought to have identified that the monies in the client accounts were beneficially the property of the master fund, at the latest at the time that substantial sums were paid into the main account, at the time of the 685,000 debacle in September 2009 when the directors resigned over their concerns. 3, at the time of the opening of the so-called house account, pleaded in D2 below. And 4, the time when the high-risk designation was applied. And 5, at some other time prior to when RBS was first approached in relation to the renaming of the accounts. So that's the pleaded case, is that one looks sequentially at what was actually happening and at the various indicia and the knowledge which the bank had over that period. 64, further in particular in view of the requirements of the money laundering codes, RBSI ought to have taken steps to identify and have identified the nature of the investment business, which, as you know, we say is clear and straightforward from the documents. The pleading then refers to this so-called house account, which, again, we would submit it was opened at an early stage. We see in November an early stage in terms of the fraud in 2009. I'm not aware that the term house account has any particular technical meaning within Isle of Man banking, but quite clearly it wasn't one of the 2 accounts that was referred to in the scheme documentation, and the bank must have been able to see very quickly indeed what it was being used for, which, as we know from the detail in this pleading and elsewhere, was to receive improperly transferred monies from the main account and then distribute them outside to the fraudsters too.
And on your case, what was the purpose of putting these funds through the house account rather than directly from the main account to the third-party accounts?
Well, my lord, it's difficult it is difficult for us to understand exactly why it was done, but the house account does appear to have been, if I can put it this way, a scion account, not a beneficiary account. So what they've done is being faced with a bit of crux. This is being faced with a position where the monies were being held in trust or client accounts. They formed a separate account, which is their account, or which they can much more easily control.
What a solicitor might call an office account.
Yes. And that, anyway, one can see from the money movements that what then happens is the money goes into the house account and is then distributed. But certainly, as a matter of simple, basic banking, we would say, it must have been obvious to the people at the bank that this was highly dodgy and certainly wasn't what the scheme documentation provided for. There doesn't seem to, there can't really have been any straightforward reason why the house account should have been formed and used in the way that it was. My lord, 61 is, as it were, the nub of the case, this application, in the sense that it's the pleaded case in relation to duties. And you've seen, if you've read this before, it's effectively divided into 2 parts, 68 and 69.
Well, hang on, 68, those are the pleaded facts relied upon to establish a duty of care. That's correct, isn't it?
Well, 68 pleads the general duty of care to exercise reasonable skill, and then the pleader has then in 69, as it were, refined the duty.
But that is by virtue of there being that duty as set out in paragraph 68.
That's right.
Yeah.
And it's then refined in terms that are reflect Barden and Quince care. It is what's called in an implied contractual context the Quince care duty.
But in relation to the paragraph 68 duty, are there any facts relied upon other than those identified in that paragraph?
Well, my Lord, in the sense, yes, as I've submitted, that we say that the duty arose whenever it did arise as a result of what was in fact occurring at whatever was the relevant date through to the events of the late 2011 and 2012, by which time we respectfully submit there had plainly been an assumption of responsibility.
Does paragraph 70 assist in that regard? Because there it seems that it's putting the basis for the duty of care on an alternative and slightly broader basis.
Yes, it's the same duty, but it's occurring in circumstances where the identity of the beneficiary is at this stage is not known to RBSI. So 70 and 71 plead that there's a duty to whoever is the beneficial owner, and as your Lordship will see from 71, about 5.
If you don't get home on 68, you don't get home on 70, do you?
Well, my Lord, we might, in the sense that 70, that the court could find on once it's found the facts that the duty existed at a much earlier stage, but that further or alternatively, if I use the standard pleading language, at the latest, by the time that they actually knew who was the beneficial owner, the duty arose at that point in late 2011. I mean, it's slightly odd in the sense that the pleadings put the 70-71 duty after the 68-69 duty. So, my Lord, that in its, as it were, pleaded summary and encapsulation is the duty. The duty in
pleading in those terms, it appears to say that the quince care duty follows the beneficial ownership of the account, so that if you either know that your customer is not the beneficial owner, or if you know who the beneficial owner is, which might be as a subset of the first type of situation, then the duty is owed to the beneficial owner.
Yes. But on the facts of the particular case, I mean, there are no doubt many instances where we would accept that it doesn't occur. And one of the points the court...
That's what we're trying to explore.
Yes.
Because that is expressed very broadly in 68 and 70, but then you seem to be limiting it by the existence of further facts. And ones that you've mentioned are that Sion was really a cipher only carrying out administrative responsibilities. Now, are you, as a further alternative, saying if we can't get home on a broad duty in 68 or 70, then we can get home on a duty which is limited by the existence of other facts, and if so, where is that pleaded?
Yes, your Ladyship's right, because 69 and 71 are what is being termed the quince care duty, whereas 68 and 70 have been pleaded in a way which is broader than that. I accept that. But the substance of the case is 69 and 71. I mean, my Lord's absolutely right that the way the present pleading has been worded by virtue of such duty refers back to the previous paragraph. But I mean, these are pleading points, if I can put it like that.
But I mean, what's troubling me, Mr. Old, is that on a pleading as broad as 70, you appear to be saying that whenever the bank's customer is a trustee, is known to the bank to be a trustee rather than a full beneficial owner of the money in the account, then the quince care duty is ipso facto owned to the beneficiaries, which might be thought to be quite a broad proposition.
Yes, although...
bearing in mind the amount of authority there is on the circumstances in which a bank may be liable to beneficiaries of a trust for misapplication of trust money.
Yes, although in fairness to the pleader, this is obviously pegged to the facts of this case. I mean, the duty refers to the client accounts and to SIAM and to the master fund and to this bank in these circumstances. So it's not seeking to say anything broader than that in every single...
But what facts is it being pegged to? I think that's what we're trying to explore.
Well,
There has to be some legal principle according to which the duty either arises or doesn't arise. You've taken us to a lot of material which could be described as red flags, and we've discussed assumption of responsibility. But what additional factors are there here that you rely on to say the duty that we're asserting here is not as broad as it might appear from 68 and 69 and 70 and 71. It's a much narrower duty because it only arises when... ... What are the dots?
Well, that in a sense, the dots, my lady, are 69 and 71, which is what is being termed the quince care duty, that if the circumstances were such that a reasonable banker would have grounds for considering that there was a serious or reasonable possibility the master fund was being defrauded or its funds misapplied, generally on specific transactions, RBS was obliged not to honour instructions in relation to the client accounts.
But that's the quince. I mean, in terms of the content of the duty, what is, i.e. the obligation imposed when the duty exists, that's the quince care duty, isn't it?
It is.
It's a, subject to correction, a relatively conventional expression of it.
Or the Baden duty. I mean, they're the standards.
All right, but let's call it the quince care duty just for convenience. I think Lady Rose's concern, and my concern, is what is special about the facts of this case so far as to trigger the arising of the duty in the first place to a person other than SIAM. Bearing in mind that quince care thus far, so far as my reading of authorities goes, but no doubt you'll tell me if I've read them wrong, is all about a duty owed by a bank to its customer.
Yes, well, quince care is, and the cases that have been referred to deal with it in a contractual context, except for Baden. And that obviously is the situation it normally arises in, but the fact that there is a contractual duty doesn't mean that there isn't also in appropriate circumstances be a tortious duty to including to the appellants in this case. But, my Lord, the way the case is pleaded and the way I put it, as I've already submitted, is that these accounts for this customer, an administrative cipher company, were put in place specifically for this scheme. That was their purpose and their only purpose. And in terms of the substance of the duty in 69 and 70, we say that this bank, RBSI, did indeed have reasonable grounds for considering that there was a real serious possibility, etc., and from an early stage, and that is sufficient, and that I don't have to show, nor does the Privy Council have to find any wider duty than that in relation to the facts of this case, really to consider whether there might be a wider duty as referred to in 68 and 70, or what appears to be a wider duty on the face of this pleading.
But are you saying, Mr. Hall, that even if there was no duty of care as alleged in paragraph 68, the facts alleged in paragraph 69 in themselves will give rise to a duty?
Yes, and that is in substance the quince care duty.
So even though there's no underlying duty of care, you say you still get your quince care duty because of the facts in paragraph 69.
Yes, my lord, in that the duty arises in those circumstances. I mean, obviously, if it hasn't arisen separately, but that is the way in which it's been pleaded. Although I accept that 68 and 71 appear on their face to plead something which is broader.
But if the trustee of a will goes to a bank and says, I'm a trustee of the will of so-and-so who's just died and I want to set up a bank account, and either does or doesn't tell the bank who the beneficiaries under the will are, do you say that the bank's knowledge that the trustee is only a trustee and that others, whether or not they've been named, are the beneficial owners of the money in the account, means that from then on the bank owes a quince care type of duty to the beneficiaries under that will trust?
Not per se.
Well, if not, why is the fact that the beneficiary is a investment scheme in the Cayman Islands a fact which imposes the duty in this case, but not in a regular will trust case?
Well, in terms of the what we're focused on, my lord, the so-called quince care duty, if the trustee in your lordship's example then started misappropriating monies which were clearly the beneficiary's money by buying himself Ferraris and yachts, the bank might, I mean, I'm not going to tackle your lordship as it were on that example, but the bank could come under a duty, the quince care duty, to refuse to make payments until it had properly investigated that the purpose in that case of the trusteeship was being complied with. But here, the material difference in a commercial arrangement, particularly in an offshore jurisdiction like this, is that the bank knew, or it's to be inferred that it knew, the proper purpose for which the monies were to be held and paid. And that purpose was perfectly clear and straightforward. And so at the point when it was or should have been quite clear to the bank that the purposes were not being operated as intended, but the money was being misappropriated, the bank was under what is in truth a very limited duty under quince care to refuse to make payments. It's not a wide floodgate sort of duty at all, in my submission. It's a very limited and straightforward duty. It involves a degree of inquiry, reasonable inquiry, as is pleaded in 69, and the bank satisfying itself as to the payments it's being asked to make, and that in circumstances where it knows that the funds belong to the beneficiary and it knows the purpose for which the payment should be made, we submit, certainly at this stage, at least as a matter of arguability, that there's every reason to allow us to develop the case at trial, that on all the facts when found, this bank was under the quince care duty to these beneficiaries, just as it accepts it was to the administrative company which was legally holding the account. In a sense, my lord, and to turn it on its head, we would go so far as to say there's a degree of absurdity in suggesting that a duty is owed to only the administrative company, which has no substantive benefit in the transaction at all, but not to the beneficial owners of the accounts, where the proximity is as close as it is in this case, and where the scheme is simple, and all the facts are known to the bank. And we don't accept, as your lordship knows, the description by the Isle of Man Court of Appeal that this is some sort of massive extension, any more than that argument held good in relation to solicitors and wills and beneficiaries in the reported cases. It isn't a massive extension. It's practical justice, to use one of the terms Lord Gough used, which is giving effect to the real world position, namely that these are our funds being held by a cipher company, which is notionally the account holder, is the account holder, is the bank's customer, and it's become plain, we say to the bank, that our money is being misappropriated through their customer by other parties, and their duty in those circumstances, which, as one of the courts already pointed out, one would have thought reflected the regulatory position, their duty was to stop it by the simple action of not making the payments.
But do I understand your submission to be, in a sense, that looking at it from the other end of the telescope, so to speak, they don't avoid the quince-care duty by interposing this administrative company that has no purpose other than formally to be a customer of the bank?
No, I agree.
Well, I'm putting to you whether or not I've understood your submission. Yeah.
Well, yeah, my lord, that your lordship is right. That to the extent that a party thought that they could avoid the substance of this by interposing a company which was technically the customer, in our submission, it has no substantive sense or justice to find that on that basis, no duty. Well, however badly the bank has behaved, whatever its state of knowledge, whatever red flags there were, and assuming that all the allegations in this detailed pleading are right, that the bank owed no duty to the people whose funds were held in its accounts.
Could I just ask you whether you would accept the proposition that your submission is that wherever a bank is on notice of fraud by its customer who is a trustee for a beneficiary, there's a duty of care owed to the beneficiary, provided that the bank knows that the funds are held on trust?
Yes, as an advocate, my lord, I'm always very cautious about accepting opposition.
Well, what I'm trying to drive at is you want us to think of facts that would bring this case away from the generality of a duty of care. But if the quince care duty is what you are relying on and an extension stroke application of it to a third party, I think we have to know what the parameters of that extension actually are. At the moment, I can't see what the narrower case is than the one I've just put forward. I mean, I can see that maybe even wider applications, because you might then say, well, why should it make any difference whether you've got beneficiaries and trustees? Why not just customers? Why not just clients of the customer who may be defrauded? But I understand you're making a point about trusts and the fact that Sion is a trustee. But are you not even going that far? And if you're not going that far, I do need to know why not? What are the facts here that you are pinning it on that don't take you as far as I've just indicated?
Well, on the assumption, my lord, that the proposition your lordship put to me is tied, as it were, to quince care, which is what we're concerned with, namely the stopping of payments because of
quince care is all about protecting the customer from fraud. What you want us to do is to protect the third party from the customer's fraud. So, in a sense, it's clearly an extension of quince care, because quince care is only, at the moment, as traditionally understood, a duty owed to the customer.
Yes, it's an implied contract.
But the content of that is, as I understand it, what you want to use, which is the bank on notice and therefore can stop fraud, and you want us to extend it to preventing loss and fraud against the client of the customer, or in this case, the beneficiary.
In a way that, by analogy, as your lordship knows, we say is similar to that, the step that was taken in White and Jones and Ross and Caunders and other cases where outside the contractual relationship, a duty was imposed in relation to a closely connected third party, because practical justice, so it was said in that case, requires it. But our submission, and you have our detailed written submissions about it, is that the decision of Peter Gibson J in Barden remains good law.
Sorry.
So we're not extending, and there's a difficulty because in this whole analysis, because Quince Care and the cases which deal with it are in their nature contract
Well, the problem I have with Peter Gibson in Barden Delvaux is development since then on two fronts would seem that there's a bit of a problem with relying too heavily on that first instance view. The first is it was based on Ans and Merton, which we know has gone. The second is it was at the time when the law in relation to dishonest assistance was still trying to work out what the standard of knowledge required was. And indeed, as you're well aware, Baden Delvaux is the case with the 5 categories of knowledge that was ultimately abandoned.
And that part was
But as a decision, Tan seems to me to have done the same on that aspect in a way that Ans and Merton, that Murphy and Brentford did to Ans and Merton. So you've got two problems, I think, in relying too heavily on Mr. Justice Peter Gibson.
Well, Your Lordship has seen that our detailed written submissions about that. We don't accept that the decision in Barden has somehow been implicitly overruled by what has subsequently occurred, either by what occurred, as if I can put it this way, the other aspect of Barden, which was overruled, or by subsequent authorities. I mean, the concession that was made and found by Mr. Justice Peter Gibson to be rightly made in Barden was that a similar duty, I mean, it wasn't called the Quince Care duty at that stage, but a duty in substance of which was similar. A similar duty did exist in circumstances which, in Barden, are very similar to the facts of this present case, where funds were held, trust funds were held and misappropriated. So the case is, we would submit, very close to this one.
But if you look at this case in terms of, just for a moment, policy and secondary liability, what you've got is a breach of fiduciary duty, and the question is whether the bank might be viewed as themselves having a duty. Now, one way of looking at that is in terms of a primary duty of care, but the other is in terms of the equitable wrong of assisting that breach of fiduciary duty. And that aspect, it's been clearly stated and decided as a matter of policy that the bank, it's not enough for the bank to be negligent, it has to be dishonest. So aren't you taking us back to a debate that's already, in a sense, been decided, that we don't want banks being held liable merely because they're negligent? They've got to be dishonest in this situation.
Those cases, my Lord, we say, relate to accessory liability and not to a duty of care in tort. That's the difference, and it is a very important difference. And I think my learned friend now accepts that. I mean, this case at an earlier stage was put very much on the basis that Your Lordship's just put it, that you can look at Tan and the other cases, and that's an end of it. And we accept, obviously, in relation to accessory liability, that dishonesty has become the test, and negligence isn't enough. But we see and put this case very differently. And so, in fairness, did Mr. Justice Peter Gibson, because although he, as it were, lost on the first point, he put as a separate case, because it was put in that way, a negligence case. And in our submission, his judgment remains good law. It's never been overturned, and if what RBSI is suggesting in this case is that the Privy Council should disapprove of it and overturn it, I would respectfully submit that you shouldn't. Well, just if I may just go back quickly to the remainder of the pleaded case. We stopped, understandably, on page 61.
By all means do, Mr. Earl. We have looked at the pleadings, and I'm conscious that you're 25 minutes away from your deadline, and you've got a lot of very interesting and important ground to cover.
Yes.
In particular, the question whether the sort of White and Jones lacuna works in relation to this case for the purpose of dealing with a supposed problem that the person who suffered a loss has no claim and the person who has a claim has suffered no loss.
Yes. Well, your Lordship has seen the overall structure of our submission.
Oh, absolutely, but we're very keen to hear you orally on those matters as well. So don't feel you have to take us through the pleadings
No.
unless they're really central to your submissions, bearing in mind how the time's going. I should say we've asked you an awful lot of questions, but it's been a very helpful process from our point of view.
No, Lord, that's absolutely fine. I'll leave the pleading on that basis, conscious, as your Lordship says at the time. I mean, in essence, the rest of the pleading sets out in great detail the relevant facts over a considerable period of time, which essentially comprise the fraud, and then pleads at the end that had the bank stopped the fraud by observing the Quince Care duty to us, a huge amount of money would be saved. Yeah. And you've seen that this is a very substantial claim for many tens of millions, because that was the extent of the fraud. So in terms of the structure of our submissions, and our ground E in the grounds of appeal is the duty based on existing authority. And to an extent, my lords and my lady, I've already covered this, because Quince Care and Singularis and JP Morgan, which are three of the cases the parties have alighted upon, are all customer contract cases. And it's really only the Barden case we would submit, which is actually concerned with whether the bank owed a duty of care to a non-customer. And as I've submitted, the Barden case is very close to this one. Yeah. On the facts. And what the banks say in relation to Barden is that it doesn't remain good law. And they say that Ross and Cornters, which was the case referred to, has been effectively altered or overruled or rendered ineffective, or whatever the right way of putting it is, by ANS and the changes in the more general law. And we simply don't accept that is the correct analysis. I mean, Ross and Cornters has remained good law and has been affirmed by White and Jones, not only in the House of Lords, but, and I won't take the Privy Council to it, but the Court of Appeal judgments in White and Jones consider specifically, I think, all of them, whether Ross and Cornters remains good law, and they find that it does. So, in our submission, the correct position in relation to Barden is that although the law has moved on, such that aspects of Sir Robert McGarry's reasoning in Ross no longer reflect the law, his conclusion was sound and can't reasonably be disputed in the light of White and Jones, which is now the leading case in the area. And that's no doubt why the passage from the Encyclopedia of Banking Law, which the Deemster relied upon in his judgment, still reflects the fact that Barden is good law.
Although it doesn't refer to Barden, does it?
No, it doesn't. No, although the wording of the paragraph is so close.
Yes, it's difficult to see where else it came from.
You see where it, no. And so we then go on to incremental extension. And that is White and Jones as a starting point. And the principles in White and Jones were developed, as the court knows, in the Gorham case and in Dean against Allen and Watts, which was another solicitor's case. And if one applies the three-stage Caparo test in this case, it was foreseeable, we submit, that RBSI, that if RBSI did not exercise reasonable care, the fund
Sorry,
would
could you say
suffer
it again? I didn't hear what you said.
Sorry.
The three-stage...
Caparo test.
Oh, the Caparo.
So the first point is it was foreseeable that if RBSI did not exercise reasonable care, the fund would suffer loss. And the relationship between the fund here as beneficial owners, as identified eventually in late 2011 by the definition of the accounts, the relationship between the fund and RBSI was sufficiently proximate, we say, and indeed very close given the nature of SIAM. Alternatively, we submit that following Lord Gough in White and Jones, the assumption of responsibility by RBSI to SIAM extends to the fund as the beneficiary on the facts of this case, and that it would be fair and just and reasonable in terms of the last element of the Caparo test for RBSI as a bank handling the bank's money to owe this Quince Care type duty, as we're calling it, to the beneficial owners of the money of the funds, namely the appellants. So we see it as a very straightforward application of the principles in that case. And you'll have seen that we refer to the Golden case at first instance, which contains a very helpful, and Golden Belt case, which contains a very helpful analysis in the commercial court of how those principles might be, indeed can be, and we say should be applied to the facts of the present case. And I don't know if your lordships and ladyship have had a chance to look at Golden Belt.
Is Mr. Justice Mayles?
That's right.
Yes.
One about the wet signature or the laser signature.
Yes, that's right, yes. But that, in the electronic bundle, it's at 1093.
Just before you move on to that, are we now supposed to be applying Caparo three-stage test directly to a novel case after Robinson and Chief Constable of West Yorkshire?
Well, ultimately, yes. And as your lordship will see, that is, I'll show you in a moment the way how Mayles J dealt with it in the case we're about to look at. So the report in Golden Belt begins at 1093 in the bundle. And at 1125, Mr. Justice Mayles begins a careful and detailed analysis under the heading Duty of Care of Law. And we see that from 1125 to 1130, he explains in detail many of the leading cases in the area before at 130 going on to the duty for which the claimants contend, and that there was an issue, as one sees in that case, as to the breadth of the duty, as there might be in here from the paragraphs of the pleading that we looked at. But certainly in what he records in 169 is that the only duty for which the claimants now contend is that the bank owed to Golden Belt and certificate holders a duty to take reasonable care that the promissory note was properly executed, with a handwritten signature, etc. He records that it's true that as originally pleaded, the duties alleged ranged much more widely. And similarly, my lord, in this case, we say this is a similarly limited duty, which we're characterising as the Quince Care duty, effectively not to comply with fraudulent payments, And it's not a duty to do nothing, as my learned friend, I think, puts it in its submission. It's a duty to refuse to make the payments you're being instructed to make until you've made reasonable inquiry. It's a duty to do something. So having identified the duty and that it is and at least by that stage in that case following the trial, a limited duty, at the bottom of 1130 he goes on to the relevant factors to be applied. And just turning those over, because obviously the Privy Council are not concerned with the facts of that case. The first one was the nature of the service provided by the bank. The second one on 1131 is the purpose of that service. On 1132, for whose benefit was the service provided. 1133, the investor's dependence on the proper execution of the promissory note. And at the bottom of that page, investors' dependence on the bank. And then over at 1135, the bank's knowledge, and then the question of to whom the duty was owed. And as your lordships have seen, ladyship has seen from our written submissions, we say all those factors, if applied, if that is a useful lens as we put it through which to view this case, all those factors would weigh very heavily in the present case in this court reaching a similar conclusion to that which we'll see Mr. Justice Mayles reached in that case. The service being provided here was the operation of accounts for the purposes of this investment scheme and ultimately for the benefit of those, the investors and the funds, the appellants who were providing the funding for the scheme. The purpose of the service was specific and limited, namely to enable the scheme to be operated so that loans could be made to solicitors in the UK. The service was being provided substantively for the benefit of the investors as part of the mechanisms within the offering memoranda to enable the scheme to operate. The investor's dependence on, it was in that case, the proper execution of the promissory note, that the investors were, as we've seen from the scheme documents, entirely dependent upon the proper performance of matters in the Isle of Man. Indeed, the scheme documentation also provides that the valuation of the investments themselves is going to be conducted in the Isle of Man, and essentially the investors had no real visibility in our case at all as to what was happening in the Isle of Man, and proceeded on the basis that the scheme was being operated in accordance with its terms. So the investors here were, we say, as with the investors in Golden Belt, dependent on the bank doing its job, as we say its job was, namely if faced with numerous indicia of fraud and all the rest of it, and having appreciated it was dealing with beneficial funds, it should have acted to make proper inquiries and or stop payments until it was satisfied. And then on 1136, Mr. Justice Mayles.
Just before you leave 1135, the case of Customs and Excise Commissioners and Barclays Bank, do you think that's a problem for your case at all? That was the case of a bank owing no duty of care to the HMRC, who'd obtained a freezing injunction to stop the customer actually going against the freezing injunction by withdrawing the funds, and the House of Lords said no duty of care owed to the third party.
Well, there's the helpful passage, as it happens, is the one from Lord Hoffman, which Mr. Justice Mayles quotes in paragraph 195 of his judgment, my Lord. In these cases in which the loss has been caused by the claimant's reliance on information provided by the defendant, it's critical to decide whether the defendant, rather than someone else, assumed responsibility for the accuracy of the information to the claimant rather than to someone else, or for its use by the claimant for one purpose rather than another. The answer does not depend upon what the defendant intended, but as in the case of contractual liability, upon what would reasonably be inferred from his conduct against the background of all the circumstances of the case. The purpose of the inquiry is to establish whether there was, in relation to the loss in question, the necessary relationship or proximity between the parties, and his lordship then refers to Henderson and Merritt. The existence of that relationship and the foreseeability of economic loss will make it unnecessary to make any further inquiry. So I mean, we say that
That he's talking about assumption of responsibility there, isn't he?
Yes, he is, yes.
And is there any assumption of responsibility case which has not involved dealings or matters crossing the line between the claimant and defendant?
Well, again, my lord, this we would submit is one of the aspects which needs to be properly explored at a trial. I mean, crossing...
What's the answer to my question? Is there a case in which an assumption of responsibility has been found?
Well, as it happens, White and Jones, my lord, the leading case is such a case because the beneficiary had no idea what was actually happening. So that is probably the clearest case.
Is White and Jones based on assumption of responsibility or the need to find a practical solution to a legal conundrum where one person has the claim and the other person has suffered the loss?
Well, my lord, both, and we make both points in this case, and the point that, as it were, I've now moved on to is the second of those of what we've called the incremental development. And in applying the tests in a way which I would submit to is very helpful, Mr. Justice Males at 1136 under the heading the three tests.
Can I just come back to the question Lord Briggs has asked, if I may? Are you relying on White and Jones to say that on our facts we are in a situation where the more obvious claimant, if you might say, hasn't suffered the loss, but the loss has really been suffered by the third party, and that therefore we're in that similar position?
Yes.
And then I would say to you, is that right? Because if you've got a trustee and a beneficiary, you might say, well, always the trustee hasn't itself suffered a loss, but you would normally expect the trustee, nevertheless, to be suing on behalf of the beneficiaries.
Yes.
So in a sense, why isn't Sion here being joined?
Because it ceased to exist a long time ago and was controlled by the crooks, as the short practical answer,
Yeah.
Lord. I mean, what we would say in terms of the terminology that the courts have used of structure or a structural issue for the purposes of the White and Case line of authorities, that this type of situation here does give rise to a structural issue in circumstances where the trustee has been controlled by the fraudsters. The monies have been misappropriated through an administrative trustee in the way that happened here. And what the court, and as Lord Gough might have put it, is doing is finding a practical justice in circumstances where Sion has never sued, is never going to sue, albeit that one accepts that it might technically have been able to, and had it done so, would have had the benefit of a contractual duty. But what the court is faced with here is a position where the ultimate beneficiaries, the underlying funds, have suffered the loss, and they're the only people who suffered the loss. So we would submit it is very similar to the White and Case position.
But a quint care duty is always going to be pursued once the person who is trusted by the company to have the mandate to authorise the payments out of the bank has lost control of the company, either because the company has been put into liquidation and now there's a liquidator in charge who will bring the action, or I suppose, as happened in the Hamblin case, where the shareholders bring a derivative claim in the name of the company. But why didn't that happen here?
Well, as a matter of fact, the company was controlled by the fraudsters. It was.
Yes, but so was in singularis. It was as well.
It was struck off, and not in a position to bring a claim. And what the Deemster said was, in relation to this aspect of the case, well, in fairness to the claimants, that is obviously a highly fact-sensitive issue which needs to go to trial. The question of what exactly happened in relation to Siam, what control the fraudsters had over it, how it came to cease to exist, is not something that can be dealt with on a strikeout application on the basis of a pleading which doesn't even refer to it. And so we respectfully submit that the Deemster was right about that, and that is yet another aspect of this case which is fact sensitive and ought to go to trial. Well, Lord, just returning, if I may, to 1136 in Golden Belt, the conclusion which His Lordship reached is on at paragraph 198.
Yes.
He concluded that the bank did owe a duty to take reasonable care to ensure the promissory note was properly executed, and it was owed to the certificate holders. Applying the objective test.
But not to Golden Belt. I mean, he makes that clear in 197.
Yes.
So here, are you saying that where the duty is owed by the bank to the beneficiaries, that is in substitution to the duty to the customer? I'm not quite sure that would work, because a contractual duty is always going to be... It
is a contractual duty, and I mean, there can also be, as Mr. Justice Steyn said in Quint's Care itself, there could be also a duty in tort owed to the customer as well as the contractual duty. But no, your ladyship's right, that is contractual. We would say both. There is no reason in principle why a similar duty cannot be owed both in contract to a customer of the bank and also to a third party, closely connected third party. There's conceptually no difficulty with that. And as his Lordship found in 199 of Golden Belt, applying the objective test, the bank assumed responsibility to take reasonable care. And it's interesting, given the discussion in this court, that is rather broader, the way that his Lordship puts it, than in fact the duty to which he was giving effect, which was like, as in this case, a much more limited duty, I would submit, there relating to the promissory note. I mean, it wasn't, as it were, a broad duty of care outside that context owed to the third party. And then he says...
Is the assumption of responsibility essentially a factual question? You look at the conduct of the defendant and ask whether it assumed responsibility, or is it something which the court can, as it were, impose as a way of dealing with a legal difficulty in establishing a duty of care owed to the claimant?
Well, my Lord, I would submit that it's both, but it certainly, in the first instance, and in the context of an application of this sort, it is one of the very matters that the court have frequently said is highly fact-sensitive. And certainly the court ought to find the facts before deciding the extent to which there's been an assumption of responsibility, if there has. And I mean, as in all strikeout applications, all the points made in my learned friend's written argument, and which he'll make orally, can all be made at trial. That ultimately what the Privy Council faces here is a question of whether the RBSI really can show that this case shouldn't go to trial at all. It's hopeless, and all the rest of it. That's why we're here. In any event, just finally on Golden Belt, my Lord, in paragraph 200, His Lordship applies the three-stage test, finding it was foreseeable that if reasonable care was not exercised, the certificate holders would suffer loss because the package of rights they received would be intrinsically flawed. The relationship between the bank and the certificate holder is sufficiently proximate. It would be fair, just and reasonable that the bank, as the arranging bank, should owe such a duty. He says in this last connection, no good reason was suggested why, as a matter of policy, an arranging bank should not owe such a duty. Seems to me there are powerful reasons why it should. To impose it would not require banks to do anything which they would not do in any event. It would not in any way undermine the contractual structure which existed in the offering circular, including the disclaimer in the important notice, and it would strengthen investor confidence. And you will have seen that we've referred to the statements of policy in relation to to ensuring the banks insist in the prevention of fraud, which Sir Geoffrey Voss gave in the Singularis case. And we do pray that policy in aid here, that in finding that a quince-care duty exists to my clients doesn't impact at all on the contractual relationship with the customer, because the two could exist side by side. And as with the case where the children and the parents both sued in relation to the solicitor's negligence, they could both have arguable duties, or only one of them could. So that we would respectfully submit that the approach helpfully taken by Males J and Golden Belt is ultimately the answer to the incremental aspect of the present case. 1 minute over my
That's all right. Thank you very much, Mr. Earl. Yes, Mr.
My Lords, following the approach of the Court of Appeal in the Isle of Man, I'm going to begin my response to my learned friend's submissions by addressing the argument that Baden is still an authority upon which the appellant, which I generally refer to as the fund, can rely on in support of the existence of the duty of care which forms the basis of this claim. I will then turn to the question of whether existing authority can be extended by analogy to support the existence of the duty of care, and I'm going to address that point in 4 stages. First, by looking at the nature of the pleaded duty of care and the basis for it. Secondly, by seeking to draw an analogy with authorities on the circumstances in which a duty of care is owed to protect against third-party wrongdoing. Thirdly, I will address the relevance of the decision in Royal Brunei Airlines and TAN. And then fourthly, I will deal with the arguments advanced regarding the extension of White and Jones. And then against that context, I will address the point on which my learned friend places so much emphasis, certainly in his written submissions and also in his oral submissions this morning, regarding whether further factual investigations are required before any decision can be reached on the question of law, which is at the heart of this appeal. And in that regard, I acknowledge, of course, from the outset that the bank's application, and indeed its position on this appeal, has always been that it's necessary to assume, for present purposes, that the fund will be able to prove the various facts that have been pleaded. But we submit that the Court of Appeal in the Isle of Man was correct in saying that on the pleaded facts, the claim is bound to fail, and therefore the claim was rightly struck out. Any factual investigation beyond that, we submit, amounts to effectively the search for the foundation of a valid claim, rather than a search for evidence to support the factual case that has been pleaded. So I turn first then to the question of whether or not the alleged duty of care is supported by existing authority. And of course the principal authority on which my learned friend relies is Baden and Societe Generale, where of course the duty of care which was accepted in that case, was conceded to exist in that case, is strikingly similar to the duty that's pleaded in these proceedings. And that was effectively an early version of the quince care duty, but a duty owed by a bank to the persons beneficially interested in the monies held by the bank's customer in an account held with the bank, in circumstances where the bank was on notice of the trust. That, in my submission, mirrors not only the nature of the duty that's been pleaded by the fund in this case, but also the basis for it. In my submission, I'm going to come back to the pleading in more detail and address what my learned friend said this morning. But in both cases, in my submission, the sole basis of the duty is the allegation that the bank knew that its customer was a fiduciary of the money held in the customer's bank account. And in my submission, that's a strikingly limited basis for a duty of this kind, particularly bearing in mind the way that the law has developed since Baden was decided. The Court of Appeal in this case, of course, rejected reliance on both Baden and the earlier decision of Ross and Coulters, which was referred to in Baden, on the basis simply that the law has moved on since then. And we see that at paragraph 36 of the judgment, which is at page 24 of the bundle. In my submission, the Court of Appeal was correct in taking that approach. The reasoning of neither case, in my submission, can be relied upon. And of course, although Baden is the most directly relevant decision, that decision is itself based on Ross and Coulters, which my learned friend contends is still good law. So that is perhaps a more useful starting point. And Ross and Coulters is found at page 1386 of the bundle. And of course, the basis for that claim is well known. It was a claim by an intended beneficiary of a will against the solicitor who acted negligently in arranging the signing of the will. And various points were raised, but the key issue that Sir Robert McGarry had to decide was the question of whether or not the claim should fail on the basis it was a claim for pure economic loss, which did not fit within what was then argued to be a narrow exception in Headley-Byrne and Heller, which was said to apply simply to negligent misstatements. And one sees, if I could ask you to turn on to page 1398, one sees there at letter D the starting point for consideration of whether a duty of care could be established. And we see, picking it up at letter D, Sir Robert McGarry refers to first Donoghue and Stevenson, then Dorset Yacht, and then Annes and Merton, all in turn, entirely unsurprisingly given the state of the law at the time. And at the top of the next page, 1399, letter B, we have the conclusion. If one approaches the present case in the manner indicated by Lord Wilberforce, I can see only one answer to the question that has to be asked at the first stage. Prima facie, a duty of care was owed by the defendant to the plaintiff because it was obvious that carelessness on their part would be likely to cause damage to her. So that's a straightforward application of Lord Wilberforce's two-stage test in Annes. There's then a quite lengthy and detailed consideration of the impact on that of various other authorities, most significantly Headley-Byrne and Heller. And as part of that, we see at page 1407, at letter D, Sir Robert McGarry considered the decision of the Court of Appeal in Ministry of Housing and Local Government and Sharp. And one sees there, he says, picking it up at the start of that paragraph, I do not think that it matters much whether that result is reached by extending the Headley-Byrne principle to such cases as Lord Denning in the Sharp case, or whether it is reached by determining liability on Donoghue and Stevenson principles and then using Headley-Byrne to extend those principles to cases of pure economic loss, as I think was done by Lord Justice Salmon. And at the end of the paragraph, he says, with great respect and considerable hesitation, I would prefer the approach of Lord Justice Salmon, although I'm happy not to be required to decide anything on the point. There's then, at 1409, what in my submission is the key culmination of this. Having considered the various tests, he says, before saying anything more about these tests of liability, I should say... Sorry,
where are you now?
I'm sorry, my Lord. Page 1409 at letter D.
Thank you.
I should say, apart from Headley-Byrne, the standard generally adopted in negligence cases is to impose liability on the general Donoghue and Stevenson basis of reasonable foreseeability. In Headley-Byrne, that basis was rejected for negligent misstatements. Instead, a more restrictive test of special skill, reliance, and so on was applied. Then he refers to the Sharp case again and then says, picking it up at the next sentence, if the general Donoghue and Stevenson basis is applied at large to cases of purely financial loss, the problems of intermediate liability are bound to occur. Cases of negligent misstatements already have the restrictive test that was laid down in Headley-Byrne. For other cases, the question is what modification or form of application of the Donoghue and Stevenson basis must be applied in order to meet these problems. So we have there a recognition that in cases of purely economic loss, some restriction on liability is needed to avoid indeterminate liability. And that comes via one of two routes. For negligent misstatements, we have the test in Headley-Byrne that is more restrictive than the Donoghue and Stevenson test. And the other route is to impose some limit on Donoghue and Stevenson. Now, of course, from today's perspective, we know that the route the law has taken has been to adopt the Headley-Byrne test and to apply it more generally than simply for negligent misstatements. The idea of applying Donoghue and Stevenson, subject to some limit for claims in pure economic loss, has been rejected. But we see Sir Robert McGarry, in fact, adopted the Donoghue and Stevenson and approach. And in the bottom half of 1409, he grapples with various different ways of limiting that test for claims of economic loss. And his conclusion, picking it up at the bottom 3 lines of 1409, he says, I do not think that I need to explore the matter further. Whichever test is applied, the facts of the present case seem to me to satisfied. I can see no reason for excluding liability. There is clearly a high degree of proximity between the negligence and loss. Plainly, the defendants not only actually knew of the plaintiff individually, without any ought to have known, but also knew the negligence would be likely to cause her financial loss. I find it difficult to envisage any test based on Donoghue and Stevenson that would be stringent enough to exclude the plaintiff. But then he goes on to say he's content, indeed happy, to leave it to other courts in other cases on other facts to evolve the test or tests that have to be applied. So in my submission, one draws 2 points from that. Firstly, this is really just a decision on its particular facts about the liability of a solicitor to the intended beneficiary under a will. It makes no attempt at all to set out a more generally applicable test for establishing a duty of care in other circumstances. And the second point is that it is a decision which starts from the perspective of Donoghue and Stevenson and Ands and Merton, which is simply no longer applicable as the basis for establishing a duty of care for claims in economic loss. A my learned friend's argument is to say that Ross and Cornters was reconsidered in White and Jones, but it was not overruled. But although White and Jones, of course, reached the same result, that the solicitor owes a duty of care to the intended beneficiary under the will, the reasoning in Ross and Cornters was, in my submission, entirely rejected. And just looking at the relevant passages in White and Jones, one sees that first at 1003. This is from the speech of Lord Gough. At letter C, we see he refers to Ross and Cornters and refers to the fact that Sir Robert McGarry approached the path traced by Lord Wilberforce in Ands and Merton. And then in the next paragraph he says, it will at once be seen that some of the conceptual problems raised by the appellants in argument before the appellate committee were not raised in Ross and Cornters. Others which were raised plainly did not loom so large in argument as they have done in the present case. And then, perhaps more definitively, at 1009, at the very bottom 2 lines of that page, running on to the top of 1010, Lord Gough says that an ordinary action in tortious negligence on the lines proposed by Sir Robert McGarry in Ross and Cornters must with the greatest respect be regarded as inappropriate because it does not meet any of the conceptual problems which have been raised. And indeed, of course, the minority in White and Jones, the Lord Keith and Lord Mustill, went further still and rejected the result entirely. And if your Lordship's note, and from a lady's note, page 1024 at letter H up to 1025 letter B, we see comment from Lord Mustill, who effectively says that the reasoning in Ross and Coulters was wrong. We have to consider afresh whether or not the same conclusion should be reached on the basis of the modern law. And all of those passages in White and Jones were noted by the Court of Appeal in this case. And it means, in my submission, that although, of course, the result in Ross and Coulters continues to reflect the law as regards the duties owed by a solicitor to an intended beneficiary of a will, the reasoning underlying that decision cannot sensibly be used as the basis for determining how the law is to be applied on other facts. So, against that background, if I could ask you to turn to Baden, and the relevant passages at page 889, paragraph 349 of Mr. Justice Peter Gibson's judgment. One sees, of course, firstly from 349, that it was conceded by the bank in that case that a duty of care was owed to those who were beneficially interested in the money that was held in the bank account where there was notice of the trust. So the point was not actually the subject of argument at all. And Mr. Justice Peter Gibson said that the concession was correctly made, firstly by reference to Anne's, that's at letter D, page 349, and then further down the page by reference to Ross and Coulters. So insofar as there are any reasons given at all for the existence of the duty of care in Baden, the basis for the decision is the approach taken by Sir Robert McGarry in Ross and Coulters, following Lord Wilberforce in Anne's, to find a duty of care based on Donoghue and Stevenson as a starting point. Now,
I think I've got the wrong page now. Did you say 349?
It's the paragraph number. Yeah.
Page 889, my lord.
Thank you so much.
It's paragraph 349.
Right, yes, it was a very long judgment. Yeah.
Now, the Fund's argument is that these cases are still based on firm underpinnings of the fundamental principles of the law of tort, as I think my learned friends put it. But in my submission, liability in respect to pure economic loss has long ago moved away from taking Donoghue and Stevenson as its starting point. Well known now that one extends Headley-Burn and Heller and goes down that route, and that's well established. So in my submission, neither Baden nor Ross and Coulters can be said to provide a proper basis for establishing a duty of care at all. And the reasoning that is adopted in Baden simply cannot be applicable, having regard to the law as it now stands. And then friend says the two cases would be decided the same way today. Well, Ross and Coulters, of course, would be decided the same way today, given what we know, the decision in White and Jones. It doesn't follow in my submission that the Baden could or should be decided the same way today at all. And in my submission, the Court of Appeal was right not to attach any weight to these authorities and to treat them as unreflective of modern law. The law has moved on, and it's necessary to consider afresh, in the light of the more recent authorities, whether the alleged duty of care is sustainable on the pleaded facts. In my submission, the Court of Appeal was right to say that it is not, and I'm going to come on to develop that in due course. And they were similarly right in my submission to not place any weight on the passage from the Encyclopedia of Banking Law, which is surely taken simply directly from Baden and has no more weight than that. It is striking in my submission that aside from Baden, there is no other authority at all that supports the proposition that a party dealing with a trustee will owe a duty of care in tort to the beneficiary simply by virtue of the party knowing that the trustee is acting as such, or knowing the identity of the beneficiary and the position in its position as such. And that is despite the fact that there have been a large number of cases involving frauds and the misappropriation of trust funds, and despite the number of cases in which attempts have been made to bring claims against third parties for dishonestly assisting a breach of trust. If a duty of care could arise in negligence of the kind alleged by the fund, that argument and the argument that they made could have been expected to have been made before. There's no trace of it having been raised, and instead the fund is basing its case on a 40-year-old first instance decision which was founded on a concession on the basis of now outdated legal analysis. In my submission, it's a novel proposition unsupported by modern authority in a factual context in which one would expect some prior authority would exist if there was some good basis for the duty of care to be established. And in my submission, the absence of such authority is telling. Just finally on the question of existing authorities, I should say something about my learned friend's reliance on the decision in Barclays Bank and Quincecare. At page 906, letter F, we see a comment by Mr. Justice Steyn in his judgment, where he refers to the need to impose a duty of care on banks to combat fraud and to protect bank customers and innocent third parties. And that reference that Mr. Justice Steyn made to innocent third parties is said by my learned friend to support the proposition that a bank might owe a Quincecare duty to a non-customer third party, which might be the victim of a fraud on a bank account. In my submission, that argument places a lot of weight on a very brief reference to third parties, which was something that was was made in the context of consideration of whether the duty was owed to the bank's customer, not to anyone else, and where the reasoning in the judgment is entirely contractual. So that reference to third parties cannot, in my submission, be taken as providing any reasoned support for the extension of the Quincecare duty to anyone other than the bank's customers.
Why did he include it then?
Well, one perhaps needs to look at the context of some of the other arguments before the court. One remembers that this case was claimed by Barclays to recover monies lent to Quincecare, which was the principal debtor, and there was also a claim against the guarantor of the loan, a company called Unichem. And of course, if the Quincecare duty had been a good defence, it would have protected Unichem's position as well as that of Quincecare, because the guarantor could have relied on the defence that Quincecare could rely upon. It's also, in my submission, a more general proposition, but one can see it in broader terms. Simply, very easy to say in general terms, the stopping of fraud to protect anyone who might be affected by it is prima facie a good thing. But that is different from saying that there is a duty of care owed to a particular third party to take steps.
And it's usually the creditors of the customer who benefit if the money is recouped from the bank.
My lady, yes.
We know from Singularis that the duty isn't owed to the creditors.
No, they benefit, but they benefit indirectly because the customer recovers the funds, and they're then distributed to the creditors in the normal way. But there's no suggestion that a duty is owed to the creditors. One can also see, it's also informative to see the arguments that Unichem, the guarantor, advanced in this case. And if I could ask you to turn on to page 913. This is the point I don't think was picked up on before. But at 913, one sees various assertions around about letter C that Unichem, the guarantor, set out in its defence. And it pleaded at 3D from the quotation, the bank well knew or ought to have known as an essential term going to the root of the loan agreement that the proposed loan should be applied in the purchase of 4 shops in Scotland owed by Parklands. And 4A, the last paragraph of the quote, in the premise that says the bank owed Unichem a duty of care to act prudently and reasonably in securing the performance and observation of all of the said terms, in particular, but not by way of limitation, so as to ensure by setting up the appropriate machinery or otherwise, and whether by immediate money transfer, book entries or otherwise, that the said loan, when and if drawn down, would be applied only for the purposes. And one then sees in the first line after the quotation that defence is rejected out of hand as being devoid of merit. And then in the last paragraph on 913, one sees there was an alternative plea. The bank owed a concurrent tortious duty coextensive with that pleaded in paragraph 4A2, which I've just read above. And again, at the top of page 914, that is rejected out of hand. But of course, despite those arguments being raised by the guarantor, there was no suggestion at all that the quince care duty, as we now call it, was owed to the guarantor. And indeed, the argument that a similar but slightly different duty was owed was rejected more or less out of hand, notwithstanding the fact that there were, of course, dealings of some kind between the bank and the guarantor. So I accept that that's perhaps a slightly more tangential point, but it is striking in my submission that there's no suggestion at all that the duty that Mr. Justice Steyn held was owed to the customer could also be owed directly to the guarantor. So in my submission, the Court of Appeal was right, paragraph 37 of their judgment on page 24, to conclude that nothing in quince care itself supports the existence of a tortious duty to a non-contracting party. The case simply doesn't support the funds claim at all. So that's existing lines of authority. I'm now going to move on to the question of incremental extension.
Yes, I'm just reflecting on your submission that apart from Baden, nothing provides authority for a duty of care owed to a beneficiary by a person dealing with the trustee. We obviously taxed Mr. Old quite hard on that. I wonder if what came out of his submission in the end was, well, what's special and distinctive here is that the bank wasn't just dealing with the trustee, but holding the beneficiary's money in the trust account. I mean, you may want to deal with that under your incremental part of your submissions or under your Baden part.
Yes, but it wasn't holding the money for the beneficiary. It was holding the money for its customer in the normal way that an account is operated for the purposes of the customer. The customer owed duties in respect of those funds to the beneficiary. But the mere fact that the bank was aware that its customer owed duties in respect of the monies that the customer was holding is not by itself, in my submission, sufficient to establish a duty of care. It may take you to the point that you can argue that it was foreseeable to the bank that the customer, the beneficiary, might be harmed if the funds in the account were lost. But foreseeability is not enough. One needs to go to the next stage and establish some basis of proximity between the bank and the beneficiary. That, in my submission, I'm going to come on to develop this in due course, but that, in my submission, requires an assumption of responsibility, given that the nature of the duty was one that involved effectively the bank protecting the beneficiary, as it's alleged, against the wrongdoing of a third party. And in those circumstances, the law is very clear in my submission that an assumption of responsibility is what is required to establish such a duty, absent some other exceptions, such as control of the wrongdoer, which are plainly not relevant on the facts of this case. One needs an assumption of responsibility, and knowledge alone, in my submission, is not enough to provide the foundation for that assumption.
So that's the point, is it, that not only is this a pure economic loss case, it's an omission case. It's a failure to protect.
My Lord, yes. Lord, I'm about to move on.
Yes, it's probably a good moment, Mr. Wheeler, so we'll resume at 2 o'clock.